I'm Rachel Leighton, Director of the Division of Energy Employees Occupational Illness Compensation with the U.S. Department of Labor. Congress established the Energy Employees Occupational Illness Compensation Program Act in October 2000. The Act provides federal compensation to individuals who developed illnesses as a result of exposure to toxic substances while working in a Department of Energy facility where nuclear weapons were developed, tested, or produced. The mission of the Department of Energy and its predecessor agencies during the Cold War and in decades following the Cold War involved workers at more than 130 Department of Energy facilities, workers at approximately 200 facilities identified as atomic weapons employers, and workers who were employed by beryllium vendors and in the uranium mines and mills located throughout the United States. Today, as a result of the Act, tens of thousands of workers or their survivors have received compensation and medical benefits under the program. Our mission in addressing the claims for benefits of these dedicated workers has been, and will continue to be, a major priority for the Department of Labor. The program involves the coordinated efforts of 4 federal agencies: the Department of Labor, which I'll refer to as DOL, the Department of Energy, or DOE, and the Department of Health and Human Services, and the Department of Justice. You'll hear me mention our partner agencies throughout this video. However, my main focus is to explain the Department of Labor's responsibility for the adjudication of claims for compensation and payment of benefits for illnesses covered under the Act. Let's start with an explanation of the 2 parts to this program, Part B and Part E. Part B went into effect on July 31, 2001. Part E went into effect on October 28, 2004. These are 2 separate programs with distinct criteria for eligibility. Let's talk about Part B of the Act. For an employee to be eligible for benefits under Part B, the medical evidence must show that the worker developed one of 4 illnesses: chronic beryllium disease due to exposures to beryllium at a covered facility, beryllium sensitivity, radiogenic cancer, in other words, a cancer caused by exposure to radiation, or chronic silicosis due to exposures to silica in the nuclear test tunnels located in Nevada and Alaska. Under Part B, the employee must have worked as a federal employee for the Department of Energy or for a DOE contractor or subcontractor during a covered time period at a covered DOE facility, have worked for a private company designated as a beryllium vendor or for a covered atomic weapons employer referred to as an AWE, or received an award from the Department of Justice as a uranium worker covered under the Radiation Exposure Compensation Act, known as RECA. Under the Act, employment evidence must establish that the employee worked at a covered facility during a covered time period. Under Part B, a covered employee may be eligible for medical benefits for a covered illness plus a one-time lump sum compensation payment of $150,000. If the employee is a uranium worker who received the RECA award of $100,000 from the Department of Justice, he or she is entitled to a one-time payment of $50,000. Your claims examiner will explain these benefits in more detail and will work with you to collect the appropriate medical and employment records to support your claim. As a claimant, you will be asked to submit medical records that show a diagnosis for each illness claimed. You will also be asked to complete an employment verification form, which DOL uses to collect employment information from the Department of Energy. DOE records can contain not only the employee's job description and personnel records, but also radiological dose records, incident or accident reports, industrial hygiene and safety records, and other information that may prove useful in developing your claim. In addition, DOL uses the Social Security Administration, the Oak Ridge Institute for Science and Education, and corporate verifiers who can help provide employment information. And we accept affidavits from coworkers or family members, plus records from state and federal agencies as further proof of covered employment. Once we've collected the required medical and employment documentation, your claim will be developed based on your illness, your work site, and your specific exposure. Claims filed by uranium workers under Part B require proof that the employee received the Section 5 RECA award from the Department of Justice for the same covered illness. For cases involving radiogenic cancer under Part B, there are 2 different routes toward development. Some cases will involve workers who developed a specified cancer and who worked for at least 250 days at a facility designated by the National Institute for Occupational Safety and Health, or NIOSH, as a special exposure cohort, or SEC facility. For these cases, the Act provides a presumption that any of 22 listed specified cancers incurred by an SEC worker were caused by radiation exposure at an SEC facility. Whenever an SEC class is added, the Department of Labor automatically reviews all affected claims to determine each employee's eligibility status under the new SEC. For cases filed under Part B involving cancers that are not covered by special exposure cohort provisions, there is an intervening step in the process called dose reconstruction. In these instances, the case is referred to NIOSH so that the worker's radiation dose can be estimated. Dose reconstructions conducted by NIOSH measure the level and extent of occupational radiation dose that workers may have been exposed to. The measurements allow DOL to determine the probability that a cancer was caused by a person's exposure to radiation. The standard is met if the cancer was at least as likely as not related to covered employment, as indicated by a determination of at least 50% probability of causation. Cases involving chronic beryllium disease or beryllium sensitivity require specific medical documentation to support your claim. The illnesses accepted in your claim are covered for medical benefits from the day you filed a claim for those conditions. The program also covers consequential illnesses identified by your doctor as having developed due to an accepted condition. Medical benefits for a covered illness under the Act include doctor's visits, medical treatments, drugs prescribed by a physician, diagnostic testing, medical equipment, inpatient and outpatient hospital costs, and authorized transportation expenses. If awarded medical benefits under the Act, you'll receive a medical benefits identification card and written instructions on how to work with your medical bill payment agent on your claim. Next, let's talk about Part E of the Act. Under Part E, benefits are provided for any illness if it can be determined that it was at least as likely as not that occupational exposure to a toxic substance was a significant factor in causing, contributing to, or aggravating the illness or death of an employee. Again, medical evidence must be submitted to establish a diagnosis for each illness. To be eligible for benefits under Part E, an employee must have worked for a DOE contractor or subcontractor during a covered time period at a covered DOE facility, or as a RECA Section 5 uranium worker. Employment evidence must show that the employee worked at a covered facility during a covered time period. Under Part E, we'll need to establish a causal link between an employee's exposure to toxic substances and his or her illnesses. First, we'll want to know which toxic substances were used in specific DOE facilities and the occupational illnesses and health effects associated with exposure to those toxic substances. DOL may also refer the claim to a medical consultant who can help determine a medical diagnosis, evaluate the cause of death, or provide an opinion on whether or not an illness is indicative of toxic substance exposure versus a natural medical process. The claim may also be referred to a health physicist, industrial hygienist, or toxicologist for review when a scientific determination regarding the case is required. Once sufficient evidence is collected and the claim is accepted under Part E, the employee will be entitled to the same medical benefits that I discussed earlier. The employee will also be eligible to file separate claims for impairment and wage loss compensation. Under Part E, a covered employee may be eligible to receive $2,500 for each percentage of impairment of the whole person that is related to the covered illness. He may also be eligible to receive wage loss benefits in the amount of $10,000 or $15,000 per year that his earnings decreased as a result of the covered illness. Under Part E, the maximum compensation is $250,000 for all claims relating to any individual employee. Next, let's talk about survivor benefits under the Act. All survivor claims require evidence to establish both covered employment and a medical diagnosis to meet standards under Part B and Part E as applicable. Furthermore, all survivor claims require evidence to establish the relationship of the claimant to the employee. Survivorship definitions under Part B and Part E are different, and there are a number of scenarios that need to be considered when determining how survivor benefits are distributed under each part. Under Part B, if the deceased covered employee is survived by a spouse who was married to the employee for at least 1 year immediately before the employee's death, the spouse is eligible to receive $150,000 lump sum payment if the causation standard is met. Survivors under Part B may also include the employee's children who are living and minors at the time of payment and who are not the natural children or adopted children of the surviving spouse. In other words, they are only the employee's children. Here, half of the compensation may be paid to the surviving spouse and the other half paid in an equal share to each child. Under Part B, if there is no surviving spouse but the employee is survived by a natural child, stepchild, or an adopted child, all of the children, regardless of age, who are living at the time of payment share the $150,000 lump sum equally. And finally, under Part B, if there is no surviving spouse and no surviving children at the time of payment, the $150,000 lump sum payment is distributed to parents, grandchildren, or grandparents of the employee in the order listed. Under Part E, if the deceased covered employee is survived by a spouse who was married to the employee for at least 1 year immediately before the employee's death, the spouse is eligible for survivor benefits under Part E. If there is no surviving spouse, survivors under Part E may also include any child of the employee who, at the time of the employee's death, was under the age of 18 or under the age of 23 and a full-time student enrolled in an educational institution, or any age if medically incapable of self-support. Part E survivor benefits include a basic lump sum compensation of $125,000 if it can be established the employee's death was caused by exposure to toxic substances in the workplace. Wage loss benefits are also available to the survivor under Part E, up to $50,000. The maximum Part E compensation benefit for a survivor is $175,000. The maximum combined federal compensation under Parts B and E, excluding medical benefits, is $400,000. For each claim, the district office will issue a recommended decision to approve or deny the claim. Where multiple illnesses are claimed, or under Part E, where you may be filing for not only medical benefits but also impairment or wage loss, or in cases where we are able to expedite certain portions of the claim, more than one recommended decision can be issued. A recommended decision is a preliminary determination only. Each recommended decision made by the district office must be reviewed by the Final Adjudication Branch, or FAB, which ensures that the Act's requirements, program policies, and procedures are followed. The FAB then issues a final decision. Before making a final decision, the FAB will consider any challenge brought by the claimant through either an oral hearing or a review of the written record. The FAB will either affirm the recommended decision or will remand a case to the district office if further development of the case is necessary. FAB may also reverse the decision in certain circumstances. A claimant may challenge the FAB's final decision by requesting reconsideration or reopening of the claim, or may file a petition for a review of final decision with the appropriate U.S. District Court. Our system of claims adjudication allows for multiple opportunities for you to perfect your claim, and we strive at each stage of the process to assist you. Also, DOL does not close the evidentiary record when our administrative process is completed. Rather, you may request a reopening of your claim at any time. We've talked about the program's eligibility requirements and about the benefits available to living employees and to survivors under both Part B and Part E of the Act. Each district office serves a particular region of the United States. Once you file a claim, your case will be assigned to a claims examiner in one of these regions. You'll be given that person's name and contact information, and together, through phone calls and written correspondence, questions and answers, you and your claims examiners will maneuver the claims process from beginning to end. We also have 11 resource centers that provide claimants in-person and telephone-based assistance. Staff members can answer your questions, help you complete the necessary claims forms and questionnaires, and show you how to gather documentation to support your claim. The resource centers can also assist you with medical bill payment process and submission of claims for reimbursement related to medical travel. I encourage you to visit our website. There you'll find information about the statute and regulations governing Part B and Part E, and you'll have access to our brochures, press releases, claims forms, instructions for electronic filing, information about town hall meetings in the district office and resource center locations, and toll-free numbers. Our division administers its responsibilities under the Act with the intent of doing what Congress intended, to pay all eligible nuclear weapons workers or their eligible survivors who incurred illnesses in the performance of duty at a covered facility. I hope this information has been helpful, and thank you for listening.